Thanks to everyone who's dialed in today. We have a really interesting discussion lined up for you on what is a pretty exciting and developing area, which is space law, and in particular, space disputes. I'm sure you all know the story of Thomas Watson, president of IBM in the 1940s, who famously predicted a world market for maybe 5 computers. I have to admit, I had a bit of a Watson-esque approach a few years ago when I was conducting some clerkship interviews and found out that a number of the students were studying space law at law school. And my initial reaction was, well, I'm sure that'll be interesting to study, but doesn't really have any real-world applications. And I'm happy to admit now that, like Watson, I was completely wrong. We're now seeing an increasing number of clients and projects involving space law and space law disputes. It's a really exciting area as a lawyer because it feels pretty cutting edge, while of course the law is based on pretty much on the existing laws and concepts that we know and mostly love. Commercial space disputes are still relatively untested. And this is also an exciting time for us arbitrators, because there are a number of features of space disputes that lend themselves perfectly to arbitration, like the need for speed, the international component, and the specialised technology. We'll touch on some of that today. But first, let me introduce the panellists. We're very lucky to have with us today as a special guest, Melissa Deswart, who's a professor at the Jeff Bleish Centre for the US Alliance in Digital Technology, Security and Governance at the Flinders University of South Australia. She's a deputy chair of the Australian Space Industry Association, a member of the International Institute of Space Law, and has lectured and written widely on the topic. Can I also introduce Brooke Hall-Carney, who is a principal at LK. Brooke is a technologist and a commercial litigator who's worked on some of the largest and most complex litigation and government inquiries in Australia. She specialises in cyber risk, data breaches, and emerging technology, including acting for clients in the space industry. Next, we have Nick Gallis, who's a special counsel at LK. At LK, and in his previous roles at 3 Crowns and at the Government of Canada, Nick has represented states and companies in many commercial and investment treaty arbitrations, including in the aerospace sector. And finally, we have Mark Giddings, who's also a special counsel at LK. Mark advises on disputes and contractual issues, including on space-related issues. He's lectured on dispute resolution as part of the University of Adelaide's Strategic Space Law course. Before we get started, I should say that if you have questions, please type them into the Q&A option on your screen and we'll try to cover them. We've only got 1 hour, so if we run out of time, we can respond individually to your questions afterwards, so you will get an answer at some point. To kick us off, I think it would be helpful to set the scene about the space industry, which is actually a growth area in Australia, and particularly here in Adelaide, where I am, which is home to the Australian Space Agency and therefore a number of other space-related organisations and startups. So to get us started, Melissa, could you please give us an insight into what type of activity we're currently seeing in the space sector?
Sure, Christy, happy to do that. So I think, as you've just said, I mean, space is very much an emerging industry. And I think we tend to think of when we think of space, we think of something very big. You know, we think of the space station, we think of space shuttles, we think of rockets, enormously big things. But I think the developments that we're really seeing in the space industry now, and particularly the Australian space industry, probably focus very much on the other end of the spectrum, the small end of the spectrum. So the really growth areas in South Australia are companies like Fleet, Myriota, Innovor, who are all focused on small satellites. They're focused on new developments in Internet of Things technology, connection, communication, and something that you could possibly even, you know, hold in your hand about this big. So I think it's important to remember that Australia has only had a space agency really for 3 years. And what this has really meant for the Australian Space Agency, and what we were lacking prior to the development or the introduction of the Space Agency, was to have a front door to business for international businesses who wanted to work with Australian companies. It was difficult because there were, 3, 4, 5 different government entities dealing with space. So one of the great things with the establishment of a space agency is we now make it clear that Australia is open for business in space industry, and it can connect and facilitate agreements with overseas. So you will have seen in the last few months, we've had announcements about partnerships with NASA to send a rover to the moon. We've had partnerships with JAXA, the Japanese Space Agency. So this means that opportunities for Australian business are becoming much more accessible. So as I said, we're moving from looking to really big things where we tend to think about, communication satellites in geosynchronous or geospatial orbit to now looking at things that are occurring in low Earth orbit. So you will probably have heard about Elon Musk deploying, tens of thousands of small satellites, and some of the disruption that's caused to the night sky. But what are they there for? Well, part of this is to provide cheap access to internet. So again, we're looking at the provision of sort of low cost technologies that are accessible to a greater number of people. So traditionally, Australia has been focused on things like ground services. So we're really, really well known for our ground stations. And of course, you can't think about the Australian space history without thinking about a movie like The Dish, where we celebrate Australians' ability to connect. But we're now also being recognised for a broader range of space activities, and it's exciting to see now discussion of things like what would the national mission from Australia be? How, as a nation, can we become a full service provider? And also looking at capabilities such as important things like sovereign capability. So with sovereign capability, again, you're looking at having a full supply chain service right through from construction and fueling of a satellite right through to launch and potentially on orbit servicing. So some of the interesting and exciting developments we've seen very recently have been test launches from Kaniba, where we've got Southern Launch at Whalers Way doing some test launches, and the construction that's going on in the Northern Territory by Equatorial Launch. So I think it's great to see that we're really looking at that full spectrum of space services. And you have a company like Gilmore in Queensland that's done a very, very successful finance raising, and Gilmore is looking at becoming that full spectrum space provider from fuel right through to launch. So the industry is now very diverse, and I think it's fair to say lots of very exciting activities that are going on, and the great opportunity for a lot of international partnerships in this area as well.
Thanks, Melissa. That's really interesting. I might turn to Mark next. Given what Melissa's just told us about, all the exciting things that are happening, what are some of the common types of disputes that might arise, or that you might be seeing arise?
Well, what you would have heard from Melissa is the diversity of different sorts of activities and different sorts of companies within the space sector. It's not one particular type of activity, it's a range of activities, and you could be a big launch provider, or you could be a small manufacturer of components which are used in the manufacture of a satellite, which then gets sent off into space. And so the sorts of disputes that you can see are disputes that arise anywhere along a long supply chain, from a dispute about the standard to which a component is manufactured, to a dispute about a missed launch date, to a dispute about whether a satellite is correctly functioning once it's on orbit. And then once on orbit, you've got various services being provided. So you can have disputes about the provision of service, about whether adequate bandwidth is being provided. And these sorts of disputes are largely contractual in nature. What makes them unique to the space industry is that there's a regulatory overlay of various bits of legislation and even international treaties which regulate the way in which the space sector operates. So to understand some of the complexities of these disputes, you need some understanding of that regulatory overlay. There's also some unique aspects to space industry contracts. They're less focused on liability for conduct and more focus on liability during particular phases of activities. And that's because it's difficult sometimes to work out what's gone wrong and to attribute liability on a fault basis. And so the contracts have a tendency to attribute liability based on the phase of the project, whether the satellite's left the factory yet, whether it's on the launch vehicle, or whether it's in space. And perhaps the other unique aspect to space industry disputes is that they tend to be cross-border and international in nature. That's just because of the fact that launch providers are spread out across the globe, and to book a launch, you might be looking at 3 or 4 different jurisdictions for your launch. And so you will be entering into contracts that involve activity in various jurisdictions. So contractual disputes largely in nature, but with some unique aspects which make them particularly interesting.
Thanks, Mark. Might turn to Brooke next. So you heard Mark say that a lot of these disputes are contractual in nature, but he touched on some of the unique aspects that make, kind of space disputes a bit different. Do you agree with the way he's described it? And what do you think are some of the industry factors that does make space disputes a bit more complex than standard contract disputes?
Well, I absolutely agree with Mark, because we work very closely in our practice, so I wouldn't disagree with him. But yeah, I would say he's absolutely right. They are contractual disputes, but I would add, and he's already touched on it, they're so factually unique, the scenarios. And the first one Mark touched on is space is such a unique environment in which to conduct activity. We've got that legal and regulatory matrix, which is so unique. We have this interaction of international treaties and guidelines. We've got international law. There's national legal frameworks. There's specific contractual structures. So you could say it's got some specificity to it. And secondly, space is such a diverse sector, which we heard Melissa start with. And you could say from the disputes perspective that it has an operational commercial field and also that military or defence field. And, it has been suggested, and we've seen it through history with the Cold Wars, that, a country or state, if you like, with that geopolitical advantage in outer space has that preeminent power across the sort of military intelligence and the science and the commercial domains. And then you add to that what Melissa said is these growing personalities of the Elon Musks and the SpaceX and the Jeff Bezos, and a number of new startups in the last few years. So my second point is, when you've got both that government, state and private entities participating, it adds this level of complexity to the disputes, which includes geopolitical and economic challenges. And there's inevitable complications when you've got a private entity and a state involved in that dispute. And a couple of examples that we could probably give in 2 recent arbitrations. There's the Antrix dispute in coming out of India. So basically Antrix is the Indian government's commercial arm of their space industry. And it was to build and launch and operate 2 satellites and sort of lease some spectrum capacity to Divas for the broadband wireless access and audio video services throughout India. Now, the Indian media were heavily critical of the government for giving away that valuable spectrum. And basically a decision was made to annul that agreement for those national needs. And that's ended up in the International Court of Arbitration. So that's where we see those sort of geopolitical challenges. And another example is a really recent one where we've got a Chinese satellite dispute, which is about to be heard by the Hong Kong International Arbitration Centre. And it's administering this dispute between a British Virgin Islands registered company called Bronzelink, and they're the major shareholder of a Cayman registered satellite technology startup. And it's got 2 US founders. And they say that they've suffered as a result of retaliation after raising concerns sort of about the Chinese government influence over the project. At the risk of oversimplification, the dispute concerns a company called Global IP's launch of a high capacity satellite over the African continent, contracting Boeing to build the satellite and also entering into a contract with SpaceX to put the satellite into orbit. So you can see with all these different contractual parties how you can get these geopolitical disputes. So I would agree with Mark. I would say they are contractual disputes, but I would add that they're very factually unique scenarios. It's a unique environment, and there's often cross-border issues that are bringing geopolitical, if you like, and economic challenges.
Great, thanks, Brooke. Yeah, there's quite a bit to unpack there, but I wanted to pick up on one of the things that I think both you and Mark mentioned, which is this additional element that relates to space, of there being kind of increase in government involvement and government regulation in a way that you maybe don't get in some of the other industries, and so that can add additional complication. So I might turn to Melissa and just ask if you could perhaps give us an overview of how the commercial space industry is regulated in Australia.
Sure, Christy, happy to do that. And I suppose this is, where I, hold up my prop, which you can see here, which are the UN space treaties. And it's funny, as a commercial lawyer, to sort of find yourself pushed very squarely into the domain of having to understand the international law governing the area. So as Brooke said, space is a very, very unique environment, and one where the international legal regime does have a very, I think, direct and immediate impact on activities for a range of reasons. So I think just a couple of fundamental points to explain why that is the case. Certainly, the way in which space law came about was, I think, in an oversimplified sense, but one way of understanding of it is to understand, as Brooke said, the Cold War context of space. So you had the two spacefaring powers, US and USSR at the time, locked in very serious competition. And if you haven't watched, something like The Right Stuff, I think, which deals with that race, then I would strongly recommend watching the Netflix show or reading the book, which really gets to the heart of the fact that, why it was that JFK said we will have a man on the moon by the end of the decade, and they just made it. But to understand that all of this was a new domain, all of this was a new frontier. And so if you think about, the principle that we were all taught way back when in property law, saying, the fundamental Roman principle is that you own the land from the center of the earth right up to the heavens. Well, what did this mean when you had human beings starting to put artificial things up into space? Like, was it permissible to have the right of overflight over another country, for example? So it's often said that the US was actually relieved when the Russians were the first to get a satellite orbiting the Earth, because that meant there was no objection under international law to that right of overflight. So these are the sort of fundamental principles that underpin space law now that were untested in times as recently as the 50s and the 60s. So recognizing, after a few unfortunate experiments, that doing things like exploding a nuclear weapon in the atmosphere was not going to go very well for anyone at all, the powers that be rapidly came to the decision that there needed to be treaties that governed the use of outer space. And to some degree, these treaties can be seen as arms control treaties. So when you understand the context of that, you understand why they're cast in the way they are. So there are 5 what we call UN space treaties. There's 4 that are reasonably well accepted. And then we have the Moon Agreement, which causes some interesting issues for Australia, but I'll get to that in a minute. So we have the Outer Space Treaty, which is recognised really as being what they call the sort of constitution of outer space, which deals with the fundamental principles, and they are very generalised principles. But importantly for us, what they do is require that nation states who are parties to that treaty essentially are responsible for authorization and supervision of space activities that are conducted from that state or by their nationals, which is the thing that requires domestic states to oversee and to license, if that's their domestic regime, and to be liable and responsible for those activities. So states parties choose how they do that. But for example, in Australia, we have the Space Activities Launches and Returns Act, which talks about what the regulations are for access to and use of space by Australians. So after that, you had the Rescue and Return Agreement, which recognised that there were going to be humans going into space, and that's an age that we are going to be returning to fairly soon. The Liability Convention, the Registration Convention, and as I've said, the Moon Agreement, which Australia is one of the very few parties to, and has raised questions most recently about whether Australia can be both a party to the Moon Agreement and to the Artemis Accords, which are an agreement between space agencies. So it's a multilateral NASA project. So as I said, we're governed by the UN space treaties. That requires Australia to supervise and, most importantly, to be liable for the actions of its nationals. So we have the Space Activities Launches and Returns Act, which was revamped and revised at the same time as the Australian Space Agency was introduced. So we have a regime which was tweaked to recognise the fact that the space industry itself was changing, and also to both pay due regard to the consequences of safety, but also in order to encourage and to support the growth of a commercial space industry. Other regulatory issues that we need to pay attention to are things like spectrum allocation by the ITU, so in Australia regulated by the ACMA. And then, of course, if we're looking at things like technology exchange, we are now in the process of negotiating a TSA between Australia and the US, and particularly, I think, in light of the recently announced AUKUS partnership, we'll see a range of new agreements having to be put into place. So again, as Brooke said, space is unique in the sense that it is everything in space is essentially dual use. It could be civilian or commercial use. So it could be up there to remove space debris, but the capacity that makes it useful for removing space debris also makes it have the potential to be weaponized. So all through space, you'll find this sort of, is it defense? Is it commercial? Increasing use by defense of commercial providers. So there's not such, I think, a bright line between what we would normally think of commercial or civilian uses and defense uses. So again, that brings some regulatory issues of its own. So all in all, plenty for lawyers there. I hope I've made it clear.
Thanks, Melissa. I think it's fair to say there's a fairly intense government and regulatory layer. And, we also talked earlier about there being an increase in this kind of commercial activity in the space sector to add an additional layer. Might direct the next question to Mark. How do you think this has changed the nature of space disputes?
Thanks, Christy. I think there's a lot to pick up on from what Melissa has said in terms of providing an overview of the historical development of space law. And I think as we've gone from nation states being the primary actors in space to private commercial entities being significant actors in space, we've seen a change in the sorts of disputes that arise and the sorts of regulation that's needed. So if we go back to when Melissa began her narrative and Melissa was talking about the Cold War, well, one of the treaties that came out of the Cold War situation was the Liability Convention of 1967, which sought to attribute liability to states based on what happens with space objects. So if a collision is caused in space between one space object and another space object, the Liability Convention steps in. Similarly, if a space object crashes to Earth and causes damage, the Liability Convention steps in, and it's got mechanisms for resolving disputes between state A and state B. And so there's a mechanism, for example, to set up a claims commission to investigate what's gone wrong. There's mechanisms for diplomatic communication to resolve disputes. And although it hasn't been directly relied upon, there has been a situation where a collision occurred to the surface of the Earth, and that was a Russian satellite in 1978, Cosmos 954, which crashed to Earth in Canadian territory. And you then had efforts between the Canadian government and the Russian government to find a diplomatic resolution. And what you had was a settlement agreement where Russia agreed to pay $3 million Canadian dollars for damage caused by that satellite crashing into Canadian territory. So that's the sort of mechanism you saw in play as the space age began. And it's a sort of mechanism where one state uses diplomatic efforts to resolve the dispute. But as we have seen increasing commercialization, what's necessary is private law mechanisms for private actors to resolve their disputes. And that's where arbitration starts to become quite important, because arbitration provides a way for private entities to litigate, to resolve commercial disputes which have a cross-border aspect to them without the direct involvement of states. And so we're starting to see an increasing number of arbitrations which are attempting to resolve these disputes. One of those disputes that Brooke has mentioned is the Davis-Antrix dispute. That's a dispute which has led to a award being rendered, and the value of the award now is something like $1.3 billion US. And if you compare the quantum of that dispute, $1.3 billion, to the quantum of the Russia-Canada dispute, $3 million, you see that the bigger, more financially significant disputes being resolved by commercial arbitration. So there's a real need for the private law dispute resolution mechanisms to fill the gap and to put in place some way for the commercial entities to resolve disputes directly with one another. So that's really the big change that we're seeing. And as we've got increasing commercialization, we've got an increasingly diverse range of entities involved in space activities. There's small startups, like the sort of small startups that Melissa has mentioned in Australia. There's small and medium enterprises, there's international governmental organizations, there's partnerships between governments and private actors. And so there's all sorts of different actors now in space, and there's a need for different sorts of dispute resolution mechanisms to step in. And arbitration is really one of the mechanisms that's come to the fore in the last 10 to 15 years.
Great, thanks, Mark. I mean, I might ask the next question to Nick, which is a bit on the flip side of the one I asked Mark. So if, as the others have described, there's an increase in commercial activity and commercial disputes in the space sector, do you think that means that governments and investment treaty type arbitrations will fall by the wayside? Do you think they still have a place in the future of space disputes?
Christy, I think it's very likely that we'll see investment treaty arbitrations in the space sector going forward. And the reasons for that, I think, have already emerged from the comments we've heard from the previous speakers. We had comments from both Mark and Melissa about the extensive government regulation in the space sector. Given that governments are very much deciding what goes into space, what comes back from space, and what things can do while they're in space, you're always going to have governments pushing up against the commercial actors in the area. In addition, Brooke mentioned that not only do we have government regulation, but we have government regulation in an area that's very sensitive for governments, in particular defence. As a result, you're going to have governments that are regulating in an area that's very important for them in a way that foreign investors might feel interferes with their rights. And that leads, I think, to a third thought, which is that certainly in the moment, and I think very likely going forward, we're in an area where there is significant foreign investment. And that's because you have knowledge concentrated in a few countries and a few companies within those countries, and they're exporting that knowledge around the world. As a result, we have and will continue to have significant foreign investment. But like I said, that foreign investment will come up against governments regulating in significantly important areas for them. And as a result, I think inevitably we're going to have investment treaty arbitrations.
Yeah, I mean, I think that's probably right. I know some of the other panelists have touched on a couple of kind of recent cases. And I just wondered, you know, I know in particular there's been some recent investment treaty arbitrations relating to space, and wondered, Nick, if you could tell us a bit more about those.
Sure. So we had mentioned the Davis dispute from the commercial arbitration angle. But in parallel with the commercial arbitration that's been spoken about, there were 2 investment treaty arbitrations launched by the investors in Devas. There was an arbitration launched under the Germany-India bilateral investment treaty, as well as an arbitration launched under the Mauritius-India bilateral investment treaty by the German and the Mauritius-based partners in that Indian locally incorporated company, Devas. Much like in the commercial arbitration, the investors succeeded. We had awards in favour of the investors about 5 years ago now, to the tune of about $100 million each. Those awards were issued about 5 years ago, and since then we've had various actions to try and enforce those awards, and efforts from India to repel the enforcement. Just recently, we've seen another investment treaty arbitration launched out of that dispute. We have one of those investors at least launching or threatening to launch another investment treaty arbitration based on the retaliation or the alleged retaliation of India in response to those awards. I think it might have been mentioned. If it wasn't mentioned, India recently forcibly liquidated the locally incorporated company Devas in India, and that action is now the focus of potentially a new investment treaty arbitration claim, when the investor is alleging that that action itself amounts to a breach of an investment treaty. So certainly in that Devas dispute, we've seen now 3 investment treaty arbitrations. There are other investment treaty arbitrations in the space sector. Just last month, we saw a report of an award released in the dispute between Eutelsat, the big French satellite manufacturer, against Mexico. The award hasn't been issued yet, but based on the media reports, it seems that Eutelsat purchased a Mexican company, and as part of that purchase, they purchased a legacy obligation for that Mexican company, and then Eutelsat, having purchased the company, to reserve a certain amount of spectrum for the Mexican government. And that amount of spectrum that was reserved for the Mexican government was more than the spectrum that was reserved by other companies. So Eutelsat alleged that this discriminated against it, and this was a breach of investment treaty obligations. In the reports we've seen in the media last month, apparently that claim did not succeed, but we'll wait and see when the award's released exactly what happened in that dispute. All to say, in answer to your question, we certainly have investment treaty arbitrations in this area at the moment, and for the reasons I said, I think we can expect to see more in the future.
Great. I think that'll be good news to those on the presentation who are specialists in investment treaty arbitrations. But I think turning back to commercial arbitrations, and I guess a similar question to you, Mark, how prevalent is arbitration in the commercial space industry at the moment? Oh, sorry, Mark, you're on mute. We had to do it once.
You can tell from the discussion so far that there is a degree of prevalence there. Some specific examples being referred to include the Devas-Antrix arbitration. And I think it's inevitable that as you get more commercial activity, you'll get more disputes. And where you get more disputes, you'll get increasing need for arbitration. And perhaps another way to answer your question, Christy, is to consider how prevalent the reliance on dispute resolution clauses are in the industry. And we see that there's fairly wide recognition that they offer a good contractual mechanism to resolve disputes. Some intergovernmental organizations, such as the European Space Agency, require that when contracting, the agency includes an arbitration clause. So IGOs are certainly using arbitration clauses. For private corporations, it's then a matter of contractual negotiation and drafting. From the agreements that I've seen advising companies in the space sector, some of those have no dispute resolution clauses. Some have dispute resolution clauses that don't refer to arbitration. Some have arbitration clauses, and some have tiered arbitration clauses. So there's quite a wide variety of approaches. Interestingly, in 2019, there was a survey published which attempted to canvass actors in the space sector, and that survey revealed that some 54% of respondents always included an arbitration clause in their contracts. So arbitration is being built in as a mechanism for dispute resolution, and I think we'll see, as there's increasing commercial activity, that there'll be increasing disputes, and therefore increasing commercial arbitrations will follow.
And what do you think those arbitrations will look like? You know, in particular, would they be run under existing institutional rules, or are there any space industry specific mechanisms for running those arbitrations?
I think what we've seen to date is that the arbitrations have been run under existing institutional rules. Brooks referred to the Devis-Antrix commercial arbitration, which was run under the ICC rules. Nick's referred to some investor-state arbitrations coming out of the Devis-Antrix dispute. They were run under the UNCITRAL rules. The Eutelsat and Mexico arbitration was run under the ICSID rules. So existing rules have been relied upon and have proved adequate to resolve space industry disputes. The other part of your question is whether there's any specific mechanisms tailored to space, and the answer is that there are. The Permanent Court of Arbitration has published in 2011 an optional protocol for arbitration relating to outer space activities. There's a number of interesting features in the optional rules. They include enhanced confidentiality mechanisms. Nick spoke about the need, about the involvement of governments, and where you have the involvement of governments, there's heightened security concerns, and indeed often IP surrounding space technology is subject to state secrecy laws. And so in the PCA optional rules, there's a series of mechanisms to allow parties, for example, to apply to have their information considered confidential. There's a mechanism to appoint a confidentiality advisor who can look at confidential information and summarize the effect of the confidential information without requiring the confidential information to be provided to the court or to the other party. So that's one of the interesting mechanisms that the PCA rules have included. Another interesting mechanism is around dealing with technical and scientific complexity, and the PCA optional rules provide for the PCA to set up a panel of advisors who can advise on technical and scientific matters. And you can see how that might be important if you've got a dispute regarding a new technology, or even in an older technology, but in a difficult to understand environment such as outer space. One of the other mechanisms for dealing with technical complexity under the PCA optional rules is that there's a mechanism by which the tribunal can require the parties to provide a simplified, non-technical summary of scientific evidence. Whether that can be achieved and would be effective might depend on the complexity of the issues involved, but it's at least attempting to address what's foreseen as the possibility of difficult information. And so we do have this set of bespoke, if you like, arbitral rules. They've never been applied to date. That might be reflective of the fact that they were published in 2011, and so haven't had a long time to sit there for parties to include them and refer to them in their arbitration clauses. It might also, though, refer to the fact that existing arbitral rules seem to do fine for most of the commercial sorts of disputes that arise, and that's probably reflective of the fact that they're largely contractual disputes, and so familiar sorts of disputes that arbitrations can address. But the PCA optional rules might be of interest where there really are security concerns and confidentiality concerns, or there really are difficult technical issues and some specific machinery is required for the tribunal to be able to deal with that specific difficulty.
Thanks, Mark. I mean, one of the things I pick up from what you were saying about the PCA optional rules is that actually a lot of it is not as much about the law, but about some of the practicalities of how do you actually deal with these disputes in practice. And I might turn to Brooke next, because you've got experience with dealing with those types of disputes. You know, particularly where often in an Australian context, they might involve like a small Australian startup on the one hand and a government or a huge multinational on the other side. How do you think this affects the resolution of the disputes in a practical way?
Yes, we act for clients, and they are predominantly startups in the space industry. And I guess a couple of things that are probably emerging that we've noticed is, first, there can be this disparity or a frequent power imbalance, if you like, between the startup and, say, a SpaceX or a NASA or another large entity that might be launching or building satellites for that startup. And that can have an impact at the other end if you end up in a dispute, that sort of contractual part. And we've seen this play out actually in the sort of arbitral seat. You might have a contract from an Australian startup with a large, satellite launch provider in the US, for example, and ultimately the arbitral seat for dispute might be London. Yes, that's terrific. We've got that sort of common law resolution mechanism available to us or our client, but it's expensive to arbitrate in London for a small startup from Australia. You probably need $1 million. So that's where we're seeing a little bit of that disparity. I mean, you're always going to have these difficulties with choice of law if there is nothing in the contract in relation to that arbitration seat. The second thing is they've also got deeper pockets when they get to that dispute end as well, if that contract is more in their favour. I think another thing to mention from that sort of practical side is the startup world is super exciting, as we know, but it's also quite unique in some respects. Traditionally our focus of lawyers has been to sort of shift as much risk to the other party, and we have punishment or penalties, for failure to meet sort of building deadlines or those sorts of things. Whereas in space, I think it's more about their mission success and getting there. So it's a different mindset of clients when you get to that sort of dispute part. And we're seeing some clear characteristics in our startup clients. There's purpose. They have this huge connection to purpose and what they're doing. They've got this incredible persistence, amazing courage, and this terrific sense of community. Now, those characteristics, when you get to a dispute, are quite different to what you're used to as a large commercial litigator. They're not always willing to give up and get out. They're still connected to the purpose and the mission, which is way more important. And they're used to failing and trying again. So that's sort of a practical thing that we're sort of seeing coming out in some of the arbitrations that we're working in. And there is a point, an expectation that things will and can always go wrong, perhaps in space compared to other industries. So, we're operating in a domain where the launch and the in-orbit phase, if you like, are inherently risky with the work that we've been doing. Also, the hardware cannot easily be accessed to repair it or replace components of it. So the precise cause of any failure cannot always be determined 100%. You can spend all you like on expert reports, but that precise cause can't be identified necessarily. And then thirdly, quickly, there's also risk is very diverse in space disputes, and it can be really hard to identify precisely in the dispute and assess it and perhaps even document it if you get to the point of an arbitral award or even a settlement before the arbitration completes. You think of an example of like a floating brick up in the sky. It might be owned by the American startup company, that actual satellite, but they don't communicate it. It might be the startup in Australia that's actually communicating to that satellite. So when you're trying to resolve that dispute, someone owns it, but someone can't talk to it. The other party can talk to it. So how do you address that sort of risk of liability going forward? And how do you mitigate the risk of debris falling out of the sky, if you like? What do we do with our floating brick? And what do you do if the German regulator rings up and says to your client, oh, by the way, you've got 3 degrees and your satellite is going to crash into the telecommunications satellite for Germany? Who wears that risk? The person who owns the satellite, or the person or the company that can only communicate to it? So we're seeing a lot of issues around that risk sort of parameters of resolving some of these sorts of disputes.
Thank you, Brooke. That was really interesting to get the kind of the practical perspective. I think we've still got a bit of time, but I think what we might try and do next is to look a bit forward and have a think about what are likely to be the biggest changes in the industry in the next 12 months. And I might turn to Melissa to answer this one.
Thanks, Christy. I suppose, 12 months is both a long and a short time in the development of the space industry, because things are happening very rapidly. I think it's going to be a very exciting time, as we know that there's going to be, and there already has been, sort of Commonwealth government and state government support for the space industry. We know that the Australian Civil Space Strategy wants the size of the space sector to triple to $12 billion, and also to grow, 20,000 jobs by 2030. Very ambitious, probably has been made significantly more difficult by the impact of COVID and the need for highly skilled workers. So I think we're going to see a lot more of activity, and I think, as Brooke was saying, a lot more activity is also going to bring with it risk. So I think that's an inevitable part of space, and I think we can get a little bit complacent. We can watch launch after launch after launch and think, yeah, we're nailing this. We've got this space stuff down pat now. It's all pretty good. But we also have to remind ourselves that there's significant risk in it. So as Brooke has said, the people who are working in this industry are very alert to this. So we had the attempted launches from Kaniba a couple of months ago, and they were not successful. And then the issue is, well, what does that mean? But in the space industry, that's really it's just another test. Okay, so what part of the process was problematic there? What part do we need to go back to the drawing board and work on? So I think that there's still a lot of work to be done in terms of understanding some technical issues here. One thing I think that is going to become an issue, or become an exciting thing in the next few years, is we're going to see the increased return of humans to space. So crewed missions, we know that part of the Artemis program is to put the next man and the first woman on the moon. And I think that those sorts of activities are incredibly inspirational. So I think, again, as these things are successful, as more and more of these missions are undertaken, that you will, I think, see more people wanting to get into the space industry. I think that these inspirational things will just draw more people in. So it's a bit of a long-winded answer to your question, and a little bit all over the place, but I think that's what's exciting about it, is that with most tech industries, it's hard to know where the next, unintended consequences boom is going to come from. Space tourism has been bubbling along for a long time, and now we've seen, proof of concept with that, with Bezos and Virgin Galactic. Attracted a lot of good publicity and a lot of bad publicity. So again, but the thing is that space is on the agenda. People are talking about space, and people are excited about space. So for the industry, that is a really good thing. But the more congested it gets up there, the more activities there are up there, the more complicated it's going to become as a regime. And for a long time, we've had the luxury of sort of knowing space that was quite big and quite empty. And it's not that big when you look at the various layers around the Earth in terms of LEO and GEO, etc. And it's increasingly congested. So these are things that we're going to have to grapple with really seriously at an international and a domestic level in the next few years.
Thanks, Melissa. If everyone will pardon the pun, it seems like a case of kind of watch this space. We actually do have a couple of questions from the audience, which we'll get to hopefully in a second. But I think we do have time for one final question for the panel from me, which I'll put to Brooke, which is a question that I could have either asked at the start or the end, which is really why have we all sat here for an hour, kind of listening to what the panel has to say? Why should those of us, particularly in Australia, care about space and space disputes?
Well, first, there's this sort of digital stack, if you like, this idea that the stack goes from the undersea cables all the way up to outer space. And we've got this rule of law matrix that sits around every part of that digital stack. There's the regulatory matrix we've heard about, the international matrix, there's an environmental matrix. So there's a whole lot of things around that sort of digital stack. And then secondly, we're seeing space is becoming, which Melissa's just touched on, it's actually, or is probably better to say, it's actually critical infrastructure. You know, we have this rapidly rising data utilisation and sort of automation, and we've got this drive into the Internet of Things. So satellite connectivity is playing a major role in that growth of the global Internet of Things sector. And it's growing at, say, I think it's above 25% annually. And it's projected by Gartner, I think, to reach something like US 1 trillion by 2027. So it's critical infrastructure for us. And Australia has some of the front runners in that capacity, particularly here in South Australia. But you've also got these sort of billionaire tycoons that Melissa mentioned, and they're seeking faster connectivity and data. And they're perhaps, if you like, even trying to escape their national infrastructure by investing in that space infrastructure in our digital stack. I think thirdly, also there's capacity. You know, additional capacity is needed in our digital stack. You know, from connectivity, the Internet of Things, we've got 5G, which is required for driverless cars. So there's this real drive for commercial mobility and faster communications. And technology is already the biggest industry in the world by market capitalisation. 5 of the biggest companies are tech companies. And many of those are taking on industry as we know it. For example, Tesla is a tech company and it's taking on car manufacturing. And we've got driverless cars. They need that satellite, they need that connectivity. So there's this insatiable demand for capacity in our digital stack. And fourthly, I think space is a means of providing access to content and service. And we've touched on that with the Internet of Things, and so has Melissa. And, you know, the satellite communication domain is still by far perhaps the largest services market that we've seen. And we're actually seeing it mature a bit and move to perhaps a SaaS model where it's, you know, satellite as a service, which is might see a bit more of in the next 12 months. And fifthly, whether we like it or not, there's money in it and there's muscle in it. This is a huge growing space. I mean, as Melissa mentioned, the space industry in Australia is worth 3.2 billion and they're looking for 12. The space economy around the world is US 350 billion, if you believe the Financial Review. You know, SpaceX is worth 74 billion. And at the same time, you've got the muscle aspect of it. You know, you've got countries with their defence and their cyber power sort of wanting to be strengthened. And it's only just recently been announced that Microsoft is going to build a couple of satellite ground stations in Australia as part of their move into the space industry. So basically, they're co-locating their Azure data centres with these satellite antennas, which are processing phenomenal amounts of data which are coming from space. Now, why are they doing that? They're doing it because it's much faster than if the data had to be shipped over the internet for processing in data centres. So that's why that sort of money and muscle point should also be mentioned. But ultimately, what's my point, just to wrap up, Christy, is because of this insatiable demand for content, services and capacity, together with that sort of technological advancement Melissa's talking about, and the likes of the new players in the market, we've got that commercialisation of space, we've got that congestion, we've got that risk. And for Australia, we have 1/3 of the world's landmass, I think, biggest landmass in the world. So that's a lot of space above us. So it's worth a lot for us. So in conclusion, I think it's only natural that we get this rise in complex cross-border space-related disputes. And I anticipate that they will increase. And at the moment, arbitration is absolutely the best for them, for these sorts of disputes.
Great, thank you, Brooke. That certainly made it, you know, made everyone understand why it was worth our time to listen to this presentation. We do have a couple of questions from the audience, and I think we actually do have time to answer them, so which I wasn't expecting, so that's good. The first one is, I'll just open it up to the panel, to the entire panel. Does the panel have any thoughts about disputes on the moon arising from safety zones? Does anyone have any thoughts on that?
I'll jump in, Christy. I think it's one of the classic instances of the development we're talking about, where previously you had a regime to regulate nation states, and now we need to move to a regime that regulates commercial actors. So the pre-existing principle was non-appropriation of the moon. No nation state owns space or can own the moon, so you can't exclude another actor from doing something on the moon. But now we want to commercialize the moon and other celestial objects, so we need mechanisms for that to take place in a safe and efficient manner. And so you have safety zones proposed as a way to exclude one commercial entity from interfering with the mining activities of another commercial entity. But how does that sit with the proposition that you can't have national appropriation of territory in outer space on the moon? There's obvious tension there. And you can see how there might be a dispute played out between one state who's engaged in activity on the moon, or whose commercial entities are engaged in activity on the moon, and another state who says, well, no, you're not permitted to do that. The moon doesn't belong to state A, it's for everybody. And so you can see some sort of diplomatic dispute might arise there. There's some remote possibility that you have that resolved through an international court that applies international law, like the International Court of Justice. But you might also have the need for the dispute between two commercial entities to be resolved. And then how is that resolved? Perhaps that's resolved through national courts, or perhaps that's resolved through arbitration. But it might be one of these instances, which Melissa spoke of, being the overflight of an object over the surface of the over the Earth, might be one of these instances where the actual practice establishes some sort of rule or way forward.
Yeah, that's interesting. Does anyone else want to add anything to that, or do you think Mark's covered the field?
I think Mark did a terrific job on what is going to be undoubtedly a very real and a very complicated issue, because of the fact it has to navigate international law and trying to make that mismatch between international law and a commercial activity. So yeah, I think there's a lot that will need to be dealt with in those arrangements on the moon. So yeah, great answer.
Great, thanks Melissa and Mark. We've got a final question, which is actually a perfect question to finish on, and again I'll open it up to the panel, which is, do any of you have any recommended reading for those of the audience who are interested in learning more about some of these space law issues on top of the things that we've discussed today?
So I could make a couple of recommendations. I think if you are interested in really just trying to understand the complicated legal environment, I would recommend Frans van der Dunk's handbook on space law. It is a very small book as opposed to every other book on space law, which is very, very large. And he breaks it down very clearly about the sort of different elements of law that apply to space. And I think it's a great introduction to sort of just understanding the complexity of the legal environment. If you just want to stay up to date with what is happening, there's a lot of really great online newsletters, and they're both Australian and international. But there's sort of Space Australia, there is Space News, and then of course you could always sign up as a member of the Space Industry Association of Australia, and that's another good way to get across what the industry is involved in.
Perfect, thank you, Melissa. And I think on that note, that might be the time to leave it. If anyone thinks of any more questions, feel free to email me. I'm at kzander@lk.law, and I can, pass it out to the panel and we can get back to you. But otherwise, I'd just like to thank all of the panelists, and in particular Melissa, for giving up her time to be with us today. And thank you to everyone in the audience for joining us.